Good morning, sir.
Good morning, ma'am.
Okay. Sir, shall we commence with the prayer, sir?
Ma'am, I think still a lot of students are yet to join. Let's wait for a minute or so and then we'll commence with the prayer.
Okay, sir. Fine. No issues.
Sure.
Shall we commence, sir?
Yes, ma'am, please.
Yes. Okay, students, let's begin our day with a and seek God's blessings for the same.
ऐश्वर्यस्य विभूषणं सुजनता शौर्यस्य वाक्संयमो ज्ञानस्योपशमः श्रुतस्य विनयो वित्तस्य पात्रे व्ययः अक्रोधस्तपसः क्षमा प्रभवितो धर्मस्य निर्व्याजता सर्वेषामपि सर्वकारणमिदं शीलं परं भूषणम् असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्योर्मामृतङ्गमय ॐ शान्ति शान्ति शान्तिः.
Yes, dear students, your schedule for the day will be law in the beginning, followed by accounts at 11 a.m. and the afternoon session also will be accounts by Adarsh sir. So be prepared, and sir is here. Over to you, sir.
Thank you, ma'am. Thank you. Good morning, friends. Today the last class with respect to Partnership Act, and let me just share the screen. Ma'am, screen sharing. Okay. Yes. So are you able to see the screen? How many of you are able to see the screen? And how many of you are excited with the magic boxes? इतने सारे magic box, sir. अरे बेटा, this is at the end of the class, but during the class we still have here 10, 10. Yes, yes, yes. So 4-5 during the class also is there. So approximately 12 to 15 magic boxes. आएगा ना मजा? Let us begin, sir. Eagerly waiting for the magic boxes. Great. My dear friend, partnership जितना सीधा दिखता है ना, उतना ही टेढ़ा है. Correct? People take it for granted. यार partnership हमने PUC में पढ़ रखा है. Accounts में कुछ कुछ बातें याद हैं. ऐसे भी बहुत छोटा सा एक्ट है. All these pre-assumptions. Correct? Today we are going to break all those pre-assumptions and make sure that no beta, हर एक concept जरूरी होता है. होता है नहीं होता है? My dear friends, very simple question. I remember Gopal's statement, the finishing touch 198 to 200. Yes or no? But आप सबको accounts पता है, maths पता है, सब कुछ पता है. The difference is just 2 on the face of it. 200 और 198 में difference सिर्फ 2 का है. But trust me, CA student के लिए वो 6 महीने का difference है. 200 लिए तो pass, 198 लिए तो come again. पता नहीं इस मैजिक बॉक्स का कौन सा बॉक्स आपको वो 2 एडिशनल मार्क दे सकता है जो आपको 198 को 200 बनाने में मदद करेगा. But I have a doubt. How many of you sitting in this class are aiming only for 200? No, sir. Why is it 200? We are aiming only for 199, sir. Correct, no? अच्छा 199 नहीं. Oh. AIR, very good. इतना पॉजिटिव. ये कौन था भाई? 450 प्लस. 450 प्लस अगर ले रहे हो तो I think you're talking about 2 attempts put together. Am I right? अच्छा ठीक है, छोड़ो बेटा, मिस्टेक हो जाता है, गलती से मिस्टेक, unintentionally done. Great. My dear friends, please understand one important aspect. If you are aiming anything less than 280 to 300, trust me, you are aiming to fail. It is very, very, very important that aim for rank, पास तो होना ही है. और क्या पता उस एमिंग फॉर रैंक में हमें सच्ची में रैंक मिल जाए. How many of you know the value of rank? Look at the difference. Whenever you are introduced to someone else, they say he is a qualified chartered accountant. People will say, अरे बाप रे, इतना बुद्धिजीवी, qualified chartered accountant. और उसके साथ अगर ये एक टर्म लगा देना, he is a qualified chartered accountant with all India rank. लोगों को आपके देखने का नजरिया बदल जाएगा. You are setting a different standards. Your parents will be proud of that moment. सीना तान के बोलेंगे बेटा ये एग्जाम सब लोग बोलते डिफिकल्ट है, मेरे बेटे ने मेरी बेटी ने रैंक लेके दिखाया है. सो एम तो रैंक का ही करना है. करेक्ट? करेंगे ना रैंक का एम. और रैंक का एम करने के लिए क्या होता है पता है? एक चीज बहुत इंपॉर्टेंट हो जाती है, एंड दैट वन इंपॉर्टेंट थिंग इज हर एक मार्क जरूरी होता है. Ask the person who scored 199 and failed. Ask a person who got just 200 and passed. What is the difference? It was just 1 mark. But एक बेचारा अभी भी फाउंडेशन रिटर्न लिख रहा है और दूसरा लकी फेलो इंटरमीडिएट लिख रहा है. That 1 mark can change the difference. All India 50th rank was say 444 marks and you got 443 marks. 1 मार्क से रैंक चूक जाना. अच्छा सर 400 में 443 नहीं आता है सर. वेरी गुड. It is to make sure are you attentive in the class or not. Okay, great. So my dear friends, if you are attentive in class, the best thing you have to do is make sure that you are doing the best. क्या कॉन्सेप्ट है? हर एक डैश जरूरी होता है, हर एक मार्क जरूरी होता है. यस नो? कल पार्टनरशिप बढ़ा था, बेसिक सब कुछ हो गया. अभी सिर्फ रजिस्ट्रेशन है, डिसोल्यूशन है, फॉर्मेशन है, डिसोल्यूशन है, रूल्स फॉर डिसोल्यूशन है. लेकिन ये जो दिया है ना, बहुत ही छोटा सा टॉपिक दिया है. 3 पेज में दोनों यूनिट खत्म कर दिए हैं. इसीलिए मैंने क्या किया, मैंने सिर्फ छोटे से पिटारेस बना दिए. बस इतने से पिटारे बनाए कि जो भी कॉन्सेप्ट थियोरेटिकली मिस हुआ है वो सब कुछ इस क्वेश्चन के माध्यम से आपका सॉल्व हो जाए. मजा आएगा ना? सर तो सर एक्ट में आपने इतने सारे मैजिक बॉक्स कहां से डाले सर? बेटा good. See, the thing is not excitement. The thing is, yes, I will do it. Eagerly waiting. Good. Act छोटा है सर, लेकिन उसकी कीर्ति बहुत बड़ी है सर. Very good. Dear friends, समझाने के लिए तो 15 मिनट में यूनिट खत्म हो सकता है, लेकिन समझाने के साथ साथ उसको कैसे प्रेजेंट करना है, कैसे लिखना है, that is important. So now let's not wait for more. It's very important that we not only understand from the examination point of view, from the subject point of view, but also from the examination point of view, that what is required to crack this kind of questions. And they are only samples. Don't be surprised if you get 0 question out of this. And don't be surprised if you get all the questions from this magic box only. So this is ICI. It could happen anything. Correct? The attempt is to make sure that we are giving you all those knowledge how to use the weapon. But exactly which weapon to use when depends upon the situation wherein Mahipal will not be present. To tell you, beta, weapon number 3 nikalna, weapon number 5 nikalna. That time it should be your logical thinking stating that yes, this question can be cracked in this way. This is what I learned in the crash course and this is how we presented it. This is what our teachers have told. Yes, maja aa gaya. With that confidence, when you hit hard, no, trust me, maja lagi hai. How many of you are really serious about this attempt to be passed, coming out with flying colors? Pakka? 100%. Shall I give you 2 important things which you should not miss before appearing for the examination? Beta, jo bhi classes bacha hai na, never miss that. You do not know, you might feel it's tiring. Okay, you might feel, I know this concept, then why should I sit in this class? Trust me, even after 100 batches of teaching, I would always surrender myself that I know things, but I do not know everything. There is always something new to be learned. The people who have taken it for granted, no, Mahipal sir ne padhaya, ab kya naya padha lenge. How many of you believe that thing has changed in the crash course? Don't you think you have got something new which was not there in a regular class? The intention of crash course is different. The intention of regular classes are different. The intent with which we study and focus is different, and the intent what is required for the examination is different. And all those Maharathis who are absent for the classes, trust me, they will feel that pain when they sit in the examination. Lot of time the students take it for granted, stating that ये तो अच्छी बात है यार, महिपाल सर ने तो पढ़ाया है, उन्हीं से तो पढ़े हैं, उन्हीं के तो नोट्स हैं, उन्हीं के एग्जाम्पल्स याद हैं. But 90% of the examples are not repeated in this foundation. Crash course. There is an entire different approach. I have never taught you how to approach the question in your regular classes. No doubt, lot of queries have come. Ki, sir, please tell us. Some students wrote and sent me on WhatsApp. But what did I do? Whoever replied, I replied them. But in this crash course, it's an entire different approach. And second important thing, beta, never miss any of the mock examination. Irrespective of wherever you are, whatever you are, however you are. I might be wrong in using this statement, but let me tell you, the intent with which I'm telling you, do not take me wrong. It's a disclaimer. It might straight away hit you. It's okay. सुनना चाहोगे कड़वा सच? The only reason you are not taking up any of the mock examination is that you are no more. Promise करो अपने आप को कि जब तक मैं हूं मैं लिखूंगा, मैं लिखूंगी. hurdles will come. The act of hurdle is to stop you. But what is your act? To move on. Will you all promise me that irrespective of situations, I will be writing all the mock examination? And trust me, my dear friend, I will give you a simple analysis. The great analysis which can open your eyes and ears. Shall I? But the analysis is very simple. With all due respect to all the students' intent, their commitment, their hard work and everything. Seeing students from last 11 years, this is what my experience says. This is what my analysis says. Student attending crash course plus mock examination versus student not attending crash course and mock examination, and the more emphasis on mock examination. Can I tell you what is the difference? If out of 10, 8 clears after attending crash course and mock examination, if you don't attempt mock examination, out of 10, only 4 clears. Already the probability of CA examination passing is very low. उसमें भी low हो जाएगी if you do not give that finishing touch. I remember Gopal sir on the introductory day said कि K2's and Trisha's mock examination are much difficult than ICI's mock examination, ICI's real examination itself. I don't know how many of you remember this statement. And I completely vouch for that statement because we are academically involved in creating those question papers. Dear friends, ऐसे ही randomly उठा के नहीं देते हैं. You can ask your seniors, those who have cleared and sitting in their intermediate level. They will vouch on that statement. When you are able to do difficult things and you have a time to understand where you've gone wrong, is much easier than finding the difficulty in the real examination. Today in the mock examination, 1 out of 400, you have scored only 100. It's okay. You still have 4 more mock examination to prepare for. And how the biggest problem happens when you write examination for formalities. Shall I tell how to prepare for mock examination and what after mock examination? The problem is students write mock exam, but they do not take an appropriate step after mock examination. Shall I tell you? I will talk only about one subject. You can correlate with other subjects. Can I? Plenty of students are sitting and sitting. Sir, khatam karo na syllabus kyun Ramayan kar rahe ho? Correct, no? नहीं, पक्का बोल दो. My dear friends, assuming today you have written law paper, 100 marks ka paper, law and your business communication, you scored say 20 marks. You were expecting that I will be scoring 45-50 marks, but you scored only 20 marks. Let's talk about the worst scenario. What should be your plan of action? Do you know? Go back to those questions. Understand that questions, what went wrong. Go back to those concepts, start reading those concepts, understand it and write it once again. Even after knowing the question, sit in the examination mode and write it once again after reading it. I know question 1, I made a mistake. I did not understand the question, or I interpreted the question in a wrong manner. That's the reason I have written a wrong answer. or I did not knew itself this concept. If you did not knew, very good, it's good, go and study that. You knew, you interpreted it wrong, then where did you exactly go wrong? Which terms made you understand this question in a different manner? Highlight that. And thirdly, the presentation. What was expected and what you have written, what is that mismatch? Understand all these three criteria, sit and write that paper once again for you. And next examination may make sure that if this kind of question comes back, I will not do the mistake. And beta, just one day before the examination, if you are able to solve all those 5-7 mock papers, whatever K2 and Trisha is going to give, plus ICAI's revision papers and ICAI's previous question papers, if you are able to do, the probability of your failure is negligible. एग्जाम के एक दिन पहले वो 500 पेज का बुक लेके बैठना, it's madness. The things which you were not able to do it in last 6 months of reading those 500 pages, you cannot do it in last 6 hours. That's the fact. Whatever was required hard work you have put in. Now it's time to be smart. Success depends upon 2 important factors. First and foremost is hard work, hard work, hard work. It's your 90% hard work and 10% that smart work. And just one day before the examination, that 10% plays a 100% role of your success. Problem kya hota hai pata hai? One day before the exam, we sit and start reading those concepts which we have never understood in last 6 months. Chhod do. It's okay. It's okay to score 90 than going for 100 and not revising those 90. How many of you got this message? How many of you understood the crux what I was telling now? In last 6 months, you have not understood 1 or 2 concepts. Trust me, even if you jump from the 10th floor and try to read, you will not be able to. क्योंकि 6 महीने में नहीं हो सकता, last 6 hours में नहीं होगा. It's okay to be prepared for 90, but make sure that 90 is prepared 100%. Than trying for 100% and not revising those 90% which you already knew. How many of you are with me? It takes a lot of pain, you know, when we see the students dropping out from the crash course and they are like, "Ye to hame pata hai." And trust me, out of experience, we tell, "Kisi ko nahi pata hai." मुझे भी नहीं पता बेटा. You might feel it's dragging. इससे अच्छा मैं और 2 chapter extra कर लेता. I know this, I could have focused on some other thing. All these are good. But don't you think we also as an academician want to plan better for you? Trust me, my dear friend, the bitter fact, none of the faculties would want their student to fail in that respective subject, at least. Agree, disagree? Don't you think I would have given 100% more efforts than the regular classes? नहीं तो रात को 2-2 बजे तक बैठ के मैजिक बॉक्स बनाना मेरे लिए जरूरी नहीं था. I could have just revised the concept and said all the best. Telling all the best is very good. But have I put in that best efforts to make sure that all the best is really the best? If we have sacrificed so much things for you, don't you think you should sacrifice for yourself, not for someone else? Beta, gyan dena easy hai. Anybody can stand and start giving gyan, lectures, everything. But the problem is how many of you are going to implement it? The problem with the motivation is what you know. It remains for fraction of minutes. मैं कितना भी बोल दूं ना, जब मेरा चेहरा देखो, वो महिपाल सर ने कुछ तो बोला था. And I know after 2-3 days you're not going to see my face till your examination. You would have forgotten it. And on the result day also you will not remember कि यार किसी प्राणी ने तो मुझे पढ़ाया था, कौन था पता नहीं वो प्राणी कौन है करके. That's not your priority at that time. My dear friend, on the result day, you are worried about your result, but I am worried about all of your results. आपके लिए result is one. For me, result is those 500 students. Tell me who should be in more tensions. And still we are fighting that battle every year, every attempt. Unfortunately, those are the things which are like discounted and discarded. And that's a fact of life, and we as a teacher understand that. कि बच्चे पास हो गए, बड़े हो गए, शायद अब हमारी जरूरत नहीं है, and they move on. नया सब्जेक्ट, नए सिलेबस, नए टीचर्स, नया अट्रैक्शंस, मूव ऑन. फाइनल में पहुंचोगे, अगेन नए सब्जेक्ट, नए सिलेबस, मूव ऑन. प्रैक्टिकल लाइफ में चले जाओगे, मूव ऑन. And life is all about move on, and you are not wrong. But my dear friends, please understand, the blessings from the teachers will never go wrong. It will always be with you, because it's not only you, it's like your success is our success. The success does not remain in I, the success is always we. कौन मुझे प्रॉमिस करेगा कि मैं एक भी मॉक टेस्ट मिस नहीं करूंगी, इररिस्पेक्टिव ऑफ व्हाटएवर मार्क आई स्कोर, दैट इज ऑल इररिलेवेंट. प्रैक्टिस मैच में 0 पे आउट होना भी ओके. प्रैक्टिस मैच में तीनों टेस्ट 0 में आउट होना इज ओके, बट फाइनल एग्जाम में सेंचुरी मारना जरूरी है. And in the lieu of scoring that century, it's okay to get out in 0. It's okay to score 200 once and see how we feel. And it's okay to score a 0 and understand how our mental stability is. And every student who is typing, sir, I promise, trust me, my dear friend, you are promising to yourself. I do not know what will be the mode of mock examination. I do not know how the corrections will happen. Because of pandemic, we are not able to meet. We are not able to understand things, but still life moves on. With whatever best available resources and with whatever best available facilities, we have tried to give you the best. I do not know how many of you have realized this. How many of you, all your friends are studying at various places, and what is the struggle they have, or what are the best thing they have. But I would love to take that pride that we have done our best. We as a team. The telecallers are going crazy to call and say them, beta attend kar lo yaar, please. The entire academic team is behind the faculty, sir, अच्छे से अच्छा question paper दो. All the coordinators are behind students की बेटा कर लो यार, कोई बात नहीं यार, कुछ नहीं, चलो आज से आ जाओ. Do you think this is required after collecting the fees? Practically speaking, no. But intention is not fees. Intention is your career. Intention is my goodwill. Intention is your success is our success. And that is the reason we are behind you. Dear friends, I will tell you one important thing. प्यासा कुएं के पास नहीं जाता है. How many of you heard this? The pond does not go to a thirsty person. The thirsty person has to go to the pond. Correct? But here, it's entirely reverse. You have the thirst and eager of clearing your examination, and we are behind you. Le lo beta, ज्ञान ले लो बेटा, ये ले लो बेटा, वो ले लो. But still, नहीं हमें तो नहीं चाहिए, हमारे पास बहुत है. All those 250 odd students attending the class, trust me, on the examination day, when you see all these 250 students clearing the examination and sitting in intermediate class together, what will be the josh, what will be the confidence, what will be the emotions attached to it? Have you ever able to visualize that scene? Trust me बेटा, एक बार visualize करके देखना, it will be a magic. Great. My intention is to make sure that I share with you whatever I believe. There are reasons why a student pass or a fail, something called as faith, which we cannot change. But have we given our 100%? If yes, let's not worry about the result. It might get delayed, but it will never get denied. If we have given our 100%, still we are able to not clear the examination, it's okay. It's okay. अगर हर कोई बंदा सीए एग्जामिनेशन फर्स्ट अटेम्प्ट में पास हो जाता तो वैल्यू ऑफ सीए वुड हैव बिकम लाइक बीकॉम. It's a professional course. Probably that finishing touch to be so called as professionalism has not come in us. Probably it requires little more drilling and finishing of hours. It's okay. Last time I gave 100%, still failed. But this time I will give 200% and make sure that I pass. I don't only pass, I have an experience of one more attempt and I will make sure that I will score a rank. Clear है? Sir, 40 minutes over, sir. अभी तो law पढ़ाना शुरू करो ना, sir. Please, sir. We are waiting, sir. Correct, no? Okay. Great. Dear friends, the only intention is another couple of class of mine is pending. And I want to put a full stop to my journey with you with a great positive note, filling you with energy and making sure that on the result day, I have tears of joy in my eyes. और सब कुछ अच्छा चला तो इंटर भी पढ़ाऊंगा. Don't worry. If you all like it, I might not say no to you. Great. चलो, जो बोलना था मैंने बोल दिया इमोशंस में आके. Let's start with the subject. Requesting you to kindly take a deep breath, relax, sit straight. Last छोटू सा concept है आज के लिए. Before we get into the magic box and understand कि इस छोटू से concept में कितने सारे पटाखे निकल सकते हैं. Correct? Relax, take a deep breath, sit straight, not on the bed, and close your eyes for a moment and promise to yourself that yes, I am the best and I will do it. If not me, who else can do it? बोलो अपने आप को. Close your eyes. I am the best. I am the best. I am the best. I will do it. I will do it. If not me, who else will do it? Come on, who is the best? Come on, yaar, who is the best? Great. Thank you, students, for acknowledging that you are the best. And trust me, you are unique. You are amazing, awesome, and you are the best. जब यहाँ पे आ जाता है ना कि I am the best, यहाँ पे आ जाता है ना I am the best. Trust me, to prove your heart and brain right, you will do all those things to prove that both are right. So दिल और दिमाग में डाल दो I am the best. अगर मैं नहीं कर सकी तो कोई नहीं कर सकता. I don't say take it as an attitude. Take it as a challenge and prove it that I am the best. Am I clear? Great. How's the Josh? Come on, yeah. How's the Josh? Great. So dear friends, let's start with the process of registration and dissolution of a firm. Okay, first and foremost thing, is registration compulsory under English law? देखो बेटा, वही गलती होता है. The thing, what you assumed by the sentence what I started, is registration compulsory? Majority of the thought under English law and wanting to type no. Sorry, under Indian law and wanting to type no. How many of you did this mistake? Assumption is a key reasons for all dash in lives. Under English law, it is compulsory, but under Indian law, it is optional. Clear? A firm can get registered anytime, either during the formation of contract or during the course of their business. Am I clear? What do you mean by the term registration? It means to say that you are formally telling the world that we are a registered partnership firm by registering yourself with registrar of the firm, and that is situated in the place of proposed to be starting your business. So registration के लिए सबसे पहली चीज क्या चाहिए? An agreement between the parties, which is called as deed. Yes or no? Great. So let us understand the procedure of registration. First of all, an application of registration is required to be made in the prescribed format. The application shall be accompanied by the prescribed fees and shall contain the following particulars: the firm name, the place and the principal place of business, the name of any other place where the firm wants to carry on the business, the date when each partner joined the firm, the name in full and permanent address of the partners, the duration of the firm. The application shall be signed by all the partners or their authorized agent. So in short, एक biodata बना लो जिसमें सब कुछ लिख लो. Clear है? And it has to be signed by majority of the partners. Majority or all? Majority or all? Great. All the partners or their authorized agent on their behalf. Am I clear? After filling this and while making the payment, what you have to do? You have to go to a place called registrar of firm, and when you have to submit this. When the registrar is satisfied with the above provision have been duly complied with, he shall make an entry in the book called Register of the Firm. Registrar of the firm, Register of the firm, and shall issue the certificate of registration. Now, registration is effective from the date when the registrar files the statement and makes the entry in the register. Any doubt? Great, great. But abhi dhyan se sunna. After registration, there might be some changes. Like one of the partner got admitted, one of the partner got insolvent, one of the partner has died. There is an admission of one more partner. Minor partner has become a major and wants to continue in the firm. All these changes, do you think will affect the registration? Will it affect the registration? Yes, yes, no, 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 yes, no, yes, no, yes, 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 yes. My dear friend, changes which are respect to admission of partner, retirement of partner, death of partner, insolvency of partner, change in additional place of business, all those things requires only and only the notification to be given to the registrar of the firm. It will not impact the registration of the firm. But if you change the name of the firm, the principal place of the firm and the business of the firm, then it requires complete new registration. Am I clear? Am I clear? So what are the three things which requires complete new registration? Come on, type it fast. The three situations under which complete new registration is required. Type fast. Change in firm name, change in principal place of business, and change in the business nature of business. Am I clear? All other changes, only the notification has to be given. Am I clear? Great. So let's start the first magic box. The first magic box is, what is the procedure for registration? Step 1, obtain the statement. Step 2, the statement information to be given. Step 3, get the statement duly verified and signed by all the partners. Step 4, file the statement along with the prescribed fees with the registrar of the firm in the area of where the firm is situated. Step 5, obtain the certificate of registration. And when will the certificate of registration will be obtained? When the registrar is satisfied with the provision and makes an entry of this statement in the book called Register of Firms. It may be noted that if any change made in the particulars filed with the registrar, the same has to be duly notified to the registrar so that he can incorporate the same in the register of the firms. Am I clear? Step 1, 2, 3, 4, 5. Yes. Clear? Great. Consequences of non-registration. First of all, we have understood that registration is not compulsory, but law directly and indirectly makes sure that the person gets registration done because there are certain disabilities. Can we see what are those? No suit in civil court by the firm or any other co-partners against the third party, which means to say an unregistered firm cannot file a case against the third party. Second, no relief of partners for set off claim, and this set off claim should not exceed rupees dash. How many of you know the concept of set off claim? Set off claim should not exceed rupees 100. How many of you do not know? Should I explain with an example? It's a mutual debt payable to each other. Assuming ABC, a partnership firm, is a registered partnership firm, and XYZ is an unregistered partnership firm. Both are in similar businesses. ABC is a dealer in, say, Samsung Mobile. XYZ is in a dealer with Nokia Mobile. Both are friends. The partners of ABC and partners of XYZ are friends. No doubt they are in competing business, but still friends. Abhi dhyan se sunna. In a Samsung, which is a registered partnership firm, any customer comes and asks for Nokia Mobile. They go for the Nokia company, they collect it from here and sell it here. In Nokia showroom, any Samsung dealer customer comes, they buy from here and sell it here. Now, assuming Nokia has supplied goods worth 50,000 to Samsung, and Samsung has supplied goods worth 45,000 to to Nokia. Now, technically speaking, 50,000 supply, 45,000 supply, the difference is only 5,000. In a layman's language, this 5,000 will be given if both are registered firm. Yes, no? This is called claim of set off. I had to pay 50, you have to pay me 45. So balance 5,000, pay and settle. Clear? But law say if it is an unregistered firm, the claim of set off should not exceed rupees 100. Now in our example, what was the difference? 5,000. Now for this unregistered firm to claim this 5,000 rupees, first they have to register themselves. Otherwise, what will happen, you know? This registered firm can file a case and claim entire 45,000. But this unregistered firm cannot claim that 50,000. And set off right is also not applicable because the difference is more than 100. Samajh mein aaya? The aggrieved party cannot bring any legal action against the partner of the firms. The third party can sue the firm. Third party can always sue, but they cannot sue the third party. Now, however, the registered for the following rights are not affected by non-registration. A third party can anytime file a case. The power of official assignee of the court to realize the property of the insolvent partner, if at all an unregistered firm is there, and one of the unregistered partners has become insolvent, the official assignee can recover the property from the firm. The right of partners to file a suit for dissolution is always available. Third, the right of firm of a partner of having no place in business in India. The right of sue claim set off not exceeding rupees 100. The partner has a right to sue for criminal proceeding against the other partner for the firm against any third party. So in case of any criminal case, it can be filed. Now let's open up the magic box. What are the effects of non-registration of a partnership firm? So all those 4 points, and then this is not affected in the following manners. This is what we have already studied. Any doubt? Any doubt? Come on, yaar. Great. Now, let's understand the term reconstitution. What do you mean by the term reconstitution? You would have learned in your accountancy, right? Restructure. Great. Change in composition of the relationship between the partners. Whenever a firm is reconstituted, dash account is created. Great. Revaluation account is created. And in case of revaluation account is created, in case of admission, goodwill might come, how to adjust with old partners. In case of retirement, how to make the payment, all those adjusting entries you pass in your accounts. Correct, no? I don't know. Great. मुझे accounts नहीं आता है ना, इसीलिए. चलो. Great. If I am correct, I am happy. If not, I will correct myself. Now, reconstitution of a firm can happen in the following manner. Number one, in case of admission of a partner. Number two, retirement of a partner, expulsion of a partner, insolvency of a partner, or death of a partner. Now, first and foremost thing, reconstitution and dissolution, in दोनों में फर्क क्या है? Dissolution of a firm and reconstitution of a firm, दोनों में फर्क क्या है? Come on यार. Reconstitution of a firm and dissolution of a firm, दोनों में फर्क क्या है? In case of reconstitution, the firm continues with the altered terms. But in case of dissolution of a firm, the existence of business by itself comes to an end. Very good. Can we proceed? Admission of a partner. Whenever there is a partner who enters into a partnership of an existing firm, a firm is said to be reconstituted. Now, for admission of a partner, consent of dash partners are required. All very good. All very good. All very good. The consent of all partners are not required in the following cases. What are those cases? Come on, कितने को याद है? No, day-to-day business was no, expulsion is no. In case of admission of a partner, consent of all partners is required. It's a thumb rule. Sorry. But consent of all partners is not required in the following cases. But I am talking about admission. In case of admission of a partner, the consent of all the partners is not required. Number one, when one of the partner reserves the right of admission. Number two, a minor partner after attaining maturity, wants to continue as a major partner. So in these two cases, consent of all the partners are not required. Am I clear? Exam में आ सकता है, याद रखना. Write a note on admission of partner. Then admission of a partner में सब चीजें लिखनी होती है. Consent is required, exception to the rule. Now next comes, what if the goodwill is bought into the business? Right to reserve admission means to say, okay, at the time of formation of contract itself, at the time of entering into the partnership agreement itself, I told the partners, all the partners, that once my son completes MBA and comes back to India, he will become a partner by default at this percentage. And all the partners have agreed for the same. So which means to say, when my son comes back, the consent is already reserved at the time of formation of contract itself. So this is called reservation of admission. Am I clear? Nikhil, Anup. When you reserve a right to admit any person. Number two, when the minor become major, अरे बाबा minor जब अंदर आया था, तब consent already ले चुके थे. Yes or no? Great. अभी ध्यान से सुनना, another concept with respect to admission. ये जित्तू सा दिखता है ना, उत्तू सा नहीं है. Okay. Assuming an incoming partner has come and he paid a goodwill so that he can enjoy the future benefit of the firm. And this goodwill is paid assuming that and agreed that the firm will continue for next 5 years. This additional amount is paid so that he can recover from the benefits reaped out of next 5 years. And the firm gets dissolved after 1 year itself. What will happen to that goodwill paid? Is he liable to receive back? If yes, under what circumstances? If no, under what circumstances? Sir, ये क्या है? नहीं पता sir. A partner who has paid additional money to become a partner, assuming that the firm will continue for next 5 years and the firm is dissolved in first year itself, can he recover the money proportionately? Can I? He cannot recover the money in case it is dissolved due to death or insolvency of a partner. Number two, if it is dissolved with respect to his misconduct in the business. Number three, the deeds had a reservation stating that it will never be given back. In such situation, he will not be paid back. But if the firm gets dissolved not on those grounds, then he is eligible to receive the refund of extra money paid. Am I clear? Why on death he will not get back? My dear friend, death is a contingency, and generally the firm gets dissolved unless until they have a right in an agreement to continue with remaining partners. Am I clear? Can we proceed? Second, retirement of a partner. When can a partner retire from the firm? Anytime by giving an appropriate notice to all other partners. Great. In case of retirement of a partner, don't you think he has to pay back his share of profits and also the money invested? If such money is not paid, then what happens? He can continue to get 6% simple interest or a share of profit without being treated as a partner. Correct? Number two, if an active partner retires, and he does not give the public notice, then he will be held liable on the ground of holding out or estoppel. Clear? Great. Number 3, expulsion of a partner. What do you mean by the term expulsion? Kicking out a partner, throwing out, kicking out, removing out, whatever it is. Now what happened? Anushka, Anusha, Bhavna and Mahipal are 4 partners. कौन है 4 partner? Anushka, Anusha, Bhavna, Mahipal. One of the day, I just was sitting and thinking, अरे यार ये भावना का चेहरा शायद अच्छा नहीं है यार, इसको निकाल देते हैं, उसकी राशि अच्छी नहीं है, जिस दिन से पार्टनर बनी है लॉस ही लॉस हो रहा है. So I told Bhavna, from tomorrow you are not a partner, get lost. Can we do that? अरे यार उसका चेहरा पसंद नहीं आया, उसकी राशि अच्छी नहीं है, उसके कारण लॉस हो रहा है, because not that she is doing good, because her राशि कुंडली में लिखा है लॉस ही होगा, तो फिर क्या करना है? Can we expel her on that ground? Bhavna, किधर हो माँ? Great. We cannot generally do that. Every partner has the right to continue into the business. Am I clear? But expulsion can be done in the following manner. Number 1, the power of expulsion of a partner should be available in the partnership deed. The majority of the partners should agree to expel, and the power of expulsion should be exercised in good faith. If it is not exercised in good faith, the partner so expelled can file a case and regain his partnership. Am I clear? अरे बाबा, expulsion पे दो चीजें हैं. If you follow this procedure, they are called regular expulsion. If you don't follow these things and say, Bhavna, तुम्हारा चेहरा अच्छा नहीं, get lost, that is called irregular expulsion. Am I clear? Great. Write a short note on expulsion of a partner. A partner may be expelled in following 4 conditions. Number 1, express power which is provided in the deed. Number 2, consent of majority of the partner. Number 3, in the good faith. And number 4, you have given an opportunity to be heard. The expulsion without satisfying those 4 set conditions is called irregular expulsion, and which is null and void. The partner who has been wrongly expelled has a right to claim the reinstallment as a partner and not to recover damages for the wrong and to recover damages for the wrongful expulsion. The rights and liabilities of an expelled partner is that same of retiring partner. Any doubt? So if there is a dispute among the partners to expel a partner, do they have to approach a law? My dear friend, if the following conditions are satisfied, you don't have to go to law. If the following condition is not satisfied, then the partner so expelled will go to court of law and claim back her partnership. Sir, if there is no notice, then expelled partner will be liable to the third partner. Yes. Sir, सीधी बात बताओ ना सर, कितने मार्क मिलेंगे इसमें? बेटा उतने ही मिलेंगे जो डिफरेंस आएगा 198 और 200 में. Sir, how can it be in the good faith? A partner is expelled in the good faith when a proper notice is given ki beta you should not do this and you are continuing to doing so. They are doing the persistent breach of duty. Because of their act, the goodwill of the firm is at stake. Then the partner is not acting in the good faith. All other partner believe that because of this has happened, and then they can expel her. Am I clear? Given an opportunity to be heard is nothing but at the time of expelling, we should say, Bhavna, dekho Bhavna, you are doing these acts which are not appropriate, and an opportunity to be given to her to rectify that mistake. Am I clear? क्या हो गया भाई? Close. अरे यार खुलना. हाँ, ये खुला ना मैजिक पिटारा. Please read this question. Understand this. This was asked in CA Foundation 2018. X, Y, and Z are partners in a partnership firm. They are carrying the business successfully for the past several years. Spouses of X and Y fought in ladies' club on their personal issue, and X-wife was hurt badly. X got angry on the incident, and he convinced Z to extirpate Y from its partnership firm. Y was expelled from the partnership firm without any notice from X and Z. Considering the provision of Indian Partnership Act, state whether the expelled partner, they can expel the partner from the firm. What are the criteria for test of good faith in such circumstances? It will be treated as irregular expulsion, null and void. Very good. All these conditions are not present. The expulsion is not deemed to be bona fide interest of the firm. The test of good faith occurs. The expulsion must be in the interest of the partnership. The partner so expelled is to be served with a notice and is given an opportunity to being heard. If the partner otherwise expelled is called irregular expulsion, and it will be null and void. According to this, the expulsion is not valid. Clear? Pakka? Insolvency of a partner. When a partner is urgent insolvent, the firm is dissolved. That is general rule. Where a partner in the firm is just insolvent, he ceases to be a partner. What do you mean by that? He's no more a partner on the date on which the order of adjustments is made. The firm is dissolved on the date of the order of adjustment, but the partner may specifically provide that all such contingency, the firm will not be dissolved. In such situation, it continues. The estate of insolvent partners are not liable for any act when the court gives an order of adjustment stating that this person is insolvent. Clear, Rohit? Great. The public notice to the effect of partner has been adjudged insolvent is not required because court order by itself is a public notice. The firm is not liable to pay for any act of the insolvent partner after the date of court telling him that he is an insolvent. Clear? General rule, the firm gets dissolved. But if a partnership deed is there to continue, then the firm continues, that partner gets eliminated. What is the date? The date on which the order has been passed by the court. Am I clear? Will that partner be liable for any act done after the court's order? Answer is no. Will the property of that insolvent partner be liable after the date of date of order of insolvency? Answer is no. Am I clear? Great. Can we proceed? Next, death. उसके बाद only magic betaras. Generally, in case of death, it comes to an end. But if it continues and the agreement provides for the same, it can continue. And what will happen to the legal representatives? They are eligible for receiving their share of profits, which was there before the date of death. In case of any act done after the death, the liability of the deceased partner's son or widow wife will not be there, and their property will not be taken into consideration. No public notice is required because that by itself is a public notice. Any doubt? Great. Sir, there are few concepts which are not explained here. क्योंकि syllabus तो खत्म हो गया as per the book. We have next limited liability. There are a lot of concepts which are missing. Minimum guarantee. नहीं पता क्या करना है. Sir, mode of dissolution, compulsory dissolution, continuing guarantee, appropriation of assets, public notice, cases where public notice is not required. What are the rights and liabilities of a partner after discontinuation? What are rights of partners in case of sale of goodwill? है ना इतने सारे concept और भी? Yes. So it's 9:20. We'll come back at 9:25, and with this 10 magic box, all those concepts will be discussed which I have just said now, and that will wind up the entire Partnership Act. Am I clear? Clear? Great. So take a break for 5 minutes. 9:25 we will be back. Gauri ma'am, we are giving a break for 5 minutes.
Yes, okay, sir. Students, kindly join after 5 minutes.
Welcome back. Is the screen clear? Able to see the video?
Yes, sir.
So I will just start playing this video and is the audio clear?
The seller
Was the audio clear and video clear?
Yes, sir. Audio and video both are clear, sir.
Thank you, ma'am.
is treated as unpaid seller under the following circumstances. 1. When whole or part of the price of the goods sold has not been paid or tendered. 2. When the goods are sold on credit and the credit period elapses and the amount is still outstanding. And 3. When a bill of exchange or other negotiable instrument has been received as a conditional payment and the conditions on which it was received have not been fulfilled by reason of the dishonor of the instrument or otherwise. Please note, the seller is not an unpaid seller if the buyer has tendered the price and the seller has refused to accept it. In such cases, the seller loses all the rights as an unpaid seller. The Sales of Goods Act 1930 has expressly given two types of rights to an unpaid seller. One of them is the right against goods sold, which includes the right of lien, the right of stoppage in transit, and the right of resale. And the other is the right against the buyer, which includes the suit for price, the suit for damages for non-acceptance of goods, the right to repudiate the contract before the due date, and the suit for interest. Let's discuss one by one. The right of lien is a possessory right, which means to retain possession of goods belonging to another person till a certain claim upon that person is not satisfied. The right of lien is a possessory right. It can be exercised only when the goods are in possession. Once possession of goods is lost, the right of lien is also lost. Right of lien can be exercised under the following circumstances. When the goods are sold without any stipulation as to credit, the unpaid seller may retain the goods if the buyer fails to pay the whole price. When the goods are sold on credit and the buyer becomes insolvent, where the seller has made part delivery of the goods, the lien may be exercised on the goods remaining in his possession. The right of lien can be exercised even if the goods are in the seller's possession in any other capacity, like that of a bailee or an agent. Note, the right of lien can be exercised only for the price and not for other charges like the down rent, interest, etc. The right of stoppage in transit is an extension of the right of lien. The right of lien is a right to retain possession, whereas the right of stoppage in transit is a right to regain possession. The right of stoppage in transit can be exercised if the goods are in transit and the buyer has not taken possession of the goods and has become insolvent in the meantime. The right of stoppage of goods in transit can be exercised by taking actual possession of the goods and or by the seller giving notice of his claim to the carrier or another bailee who holds the goods. The right to stoppage in transit is lost under the following circumstances. 1. If the buyer or his agent obtains possession of the goods. 2. If after arrival of the goods at the appointed destination, the carrier or the bailee acknowledges to the buyer that he holds the goods on his behalf. Right of resale. If the buyer fails to pay or offer the price within a reasonable time, an unpaid seller has the right to resell the goods in these cases. 1. When the goods are of a perishable nature. 2. When the seller has expressly reserved the right of resale. And 3. In other cases, where the unpaid seller has failed to get his price from the buyer. He may resell the goods by giving notice of his intention to the buyer. Note, in case of resale, if there is profit, then the seller is entitled to retain it, but if there is loss, the seller can recover this loss from the buyer. Let's discuss seller's rights against the buyer. 1. If the buyer does not pay the price in terms of the contract, the seller may bring legal action against the buyer for payment. 2. If the buyer wrongfully neglects or refuses to accept the goods, the seller may bring legal action against the buyer for recovery of damages suffered due to non-acceptance of the goods. 3. When there is a specific agreement between the seller and the buyer regarding interest on the price of the goods, from the date on which the payment becomes due, the seller can recover the interest. Let's understand auction sale. A sale by auction is a public sale where different intending buyers assemble and try to outbid each other. The goods are sold to the highest bidder. The offer of a price is a bid, and the person offering the price is a bidder. The relationship between the owner and the auctioneer is that of a principal and an agent and is governed by the general principles of the law of agency. These are a few rules with regard to an auction sale. 1. The bid. When a person bids, it is only an offer, and his bid is deemed to be accepted by the fall of the hammer or by calling 1, 2, 3. The bid can be withdrawn before it is accepted. 2. The sale of goods in lots. Each lot in prima facie deemed to be the subject of a separate contract of sale. This rule can be excluded by an agreement. 3. The transfer of ownership. On completion of sale by the fall of the hammer, the ownership of the goods is immediately transferred to the highest bidder, who becomes the buyer. And 4. The completion of an auction sale. The sale is complete when the auctioneer announces its completion by the fall of the hammer and in some other customary manner. For example, by calling 1, 2, 3 or going, gone. Please note, any rule which does not permit a bidder to withdraw his bid before it is accepted is invalid. It is against the provision of the law that an offer can be revoked before it is accepted. For example, suppose in an auction sale, there is a notification like this: a bid once made shall not be withdrawn. And one of the bidders who makes a bid wants to withdraw it before the fall of hammer. Held, he is entitled to withdraw his bid before it is accepted. In addition to these, we have other key elements in an auction sale. They are: 1. Reserve price. This is the lowest price below which the auctioneer will not sell. Where the sale is notified subject to the reserve price, the buyer is bound by the reserve price even if the auctioneer by mistake accepts a bid lower than the reserve price. 2. Knockout agreement. In this case, the buyer joins hands to eliminate competition amongst themselves at an auction sale. A knockout agreement is not illegal. However, if the intention of the parties to the agreement is to defraud a third party, it is considered illegal. And 3. Damping. This is an illegal act dissuading the intending buyer from bidding. It includes pointing out defects in the goods, or misleading the purchaser, or committing any other act so that he may not participate in the auction.
Yes, my dear friends, कैसा लगा रिविजन? Unpaid seller auction sale, one of the important concept for your CA foundation examination. मजा आया? Good. Students का response बहुत slow आ रहा है. I think is auction sale an invitation to offer? The answer is yes. Great. Sir, it was okay, sir. It was good, sir. It's better, sir. It could have been better, sir. ठीक है, हम भी सीखते हैं बेटा. 9 minutes, the concept is done. Sir, partnership का video वो भी आएगा बेटा. I have not developed this company and LLP. Partnership का भी है. Don't worry. कल क्लास में कुछ तो दिखाएंगे ना. Great. So can we move back to those magic boxes and understand the other concepts? How is the Josh? Come on, yaar. How is the Josh? Great. Great. Ready? Begin. Go. First question. Write a note on mode of dissolution of a firm. How many of you are able to recall something? Mode of dissolution of a firm. कुछ कुछ तो याद आ रहा है. Mode of dissolution of firm. क्या क्या याद आ रहा है? फटाफट. There could be voluntary dissolution. There is a dissolution by court. Voluntary dissolution can happen in the following manner. Court will come into the picture in the following manner. Compulsory dissolution. Okay. At will, at by notice. Great. Let's see what was the expected answer. It's a 4 marker, so just tuck bullets. अगर एक question 6 mark या 8 mark का होता, then every statement should have been given with a one-liner explanation. Clear है? So dissolution by agreement, whenever partnership is at will, by an agreement, so if the partnership is created for a specific period, it can come. By operation of law or compulsory dissolution, while happening of a certain contingencies like death, insolvencies, by notice to all the partner. Sir, what is partnership at will? Very good. But a partnership at will is a partnership which is created and at will and can be continued till the willingness of all the partners. It can be dissolved any time by giving an appropriate notice to all other partners. The court will come into the picture and will dissolve when the partner becomes unsound mind, permanent incapacity, misconduct, persistent breach of duty, transfer of interest, business working at loss, and just an equitable ground. So 4 markers के लिए इतना ही बस है. अगर एक question 8 markers के लिए है, then explain each concept. Tuck. What is incapacity, sir? Mahipal is a law teacher and he is one of the partner in the partnership firm. Mahipal ka vocal cord out. I have become incapable to carry on my. Yes, no. So in case of permanent incapacity, can a person who has become incapable file for dissolution? Generally, the other person who is not become incapable should file. Sir, interest can be transferred? No, sir. It should be transferred with the consent of all the partners. If it is not with consent of all the other partners, it will not be treated as transfer. The transfer should be whole, not necessarily. Clear? What is equitable ground means? Any other grounds. When you end up giving up, it is called end of thinking capacity, etc. So D point, persistent disagreement of a partnership agreement. Anguta chap partner cannot see the books, if you remember Ramesh, right? Ramesh, clear? देखो कितना simple है line. Thank you, Nivedita Anguta chat partner. Thank you, Nivedita, if you are there. You have been remembered by the entire class. That's the power of being a bakra or a bakri. Sir, explain point E. Point E is transfer of interest. I become a partner, I transfer all my rights to my son without taking the consent of all other partners. And now my son starts questioning this, that, everything is not valid. Clear, Harold? Can we close this first magic box? What is deadlock? Deadlock generally means where you're cornered and you don't have a choice but to continue, or it can put at end where there could be strikes or something like that. So generally it's a cornered position. Persistent breach of agreement, I already told you, if one of the partner is not allowed to carry on certain activities in a partnership firm by an agreement, and such partners continue to breach those agreement, which is not in the favor of the welfare of the company, sorry, of the partnership firm. Clear? So magic box number 1 got over. Magic box number 2. Write explanatory note on mode of giving public notice. पब्लिक नोटिस कब देना चाहिए, कब नहीं देना चाहिए, क्यों देना चाहिए, पब्लिक को नोटिस होता क्या है? Anybody? Come on, सोचो सोचो क्या आंसर आ सकता है? Come on guys. Come on. How many of you understood this question? Let's open the answer. For the purpose of formalities that must be accomplished by public notice in case of registered firm, it should be notice given to the registrar, publication in official gazette, and publication in one of the vernacular newspaper. In case of unregistered firm, public notice is not required, but public notice are not required in case of registered firm in the following manners. When the partner, a public notice is necessary in the following cases: when the partner retires, when the firm is dissolved, when the minor has attend the majority and he wants to continue in the firm. Am I clear? Clear? What is a vernacular newspaper? In case of admission, is public notice necessary? No. But an intimation to registrar of firm is necessary. Vernacular newspaper is a daily newspaper in the local language. Karnataka, Kannada newspaper. Tamil Nadu, Tamil newspaper. Maharashtra, Marathi newspaper. Newspaper of religion language. Official Gazette is a magazine published by registrar of the firms or a notification by registrar of the firms. Clear? Box number 3. Write a note on partner's authority in emergency. When can a partner act in emergency, and what would be the liability of the firm against the partner? Or what are the authorities of a partner acted in emergency? Come on, socho, fatafat socho. He can bind the firm, provided dash and dash are satisfied. He must be indemnified by the firm. Yes, agreed. But when? Reasonable. No. Arol, your answer is wrong. Under reasonable circumstances. Anup, explain the reasonable circumstances. When he acts in the ordinary course of business. Yes, to an extent, 100% right. Reasonable expenses to reduce loss for the firm. Yes. To prevent the losses. Yes. When the company debts to pay and the partner pays on his behalf, that is not an emergency. That is called subrogation in case of dissolution. Okay. Let's not dig too much into it. Let's open it. A partner's authority in emergency covers those acts which fulfill the following two conditions. The act must have been done to protect the firm from the loss, and the act must have been such as prudent man would have undertaken in the similar circumstances in his own case. It may be noted that these acts do not form part of implied authority of a partner, but nevertheless they would bind the firm. So act should have been done in the firm name, and it should have been done in the regular course of the business. It should be to protect the firm from the loss, and he should make sure that he is reducing the cost as if it is considering if it was his own cost. Am I clear? Then only the firm will become liable. Clear है? इसको थोड़ा और elaboratively भी लिख सकते हैं. Clear? So 3 magic box. Sorry, sir. I have not understood the question. What are the authorities of a partner in emergency? Okay. Emergency में अगर partner कुछ काम करता है, partner was not liable to deliver certain goods, but there is an emergency. If the goods are not delivered on time, the order will get cancelled. Now partner has to act on it. Will he wait for the authority of all the other partners to give the consent, okay, on behalf of the firm you act? No, he would have acted in a good faith in the firm name to make sure the firm does not suffer any loss, and would have taken the precautionary step to reduce the cost of performance as a normal human being could do if it was his own cost. Then all those acts done in an emergency will be liability of the firm, and he will be indemnified by the firm. Clear, Nikhil? Great. So 3 magic boxes over. Let's move on to the 4. क्या क्वेश्चन इतना बड़ा है क्या? A, B, C, D, E, F, G, H, I, J. Yes, Ronson, you got it right. X, Y, Z are partner in a firm. State whether the court will pass an order for dissolution of a firm in each of the following alternative cases. Number 1, if X, an active partner, becomes insane and a suit is filed by X next friend or who is not a partner. Yes, 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 no. Yes, no. पूरा क्वेश्चन ध्यान से सुनो और फिर बताओ. Yes, yes, no, 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 no. ठीक है. We'll reserve the answers. Yes and no, mixed opinion. Number 2, if X, a dormant partner, becomes insane and the suit is filed by Y. Question number 2 started. Case B. Yes, no, 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 yes, no, no. Sir, confusion. Yes, no, yes, no, not necessarily. Great. Let's move again. A mixed opinion, but majority of them no, few yes. Great. Beta, suit for what? Suit for dissolution. Beta, will the court pass a order of dissolving the firm in the following cases? Is the question. Clear, Ronson? Suit for dissolution, beta. Number 3, if X had an attract of paralysis and the suit is filed by Y. According to doctor, paralysis was a temporary nature and the patient condition was improving. No, no, no. Question number 3 ka? Yes. Nikhil says yes. Ronson says no. Roshni says no. Manoj no. Suma no. Prithvi no. Yes. Sudarshan say yes. No, 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 no. Great. Can we move on? Next. If X has adulterous relationship with Y's wife. Question number 4 ka bhi answer. No. 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 सर क्वेश्चन नंबर 4 थोड़ा ज्यादा समझ में नहीं आया सर. फिर भी आप बोलो तो यस या नो बता देता हूं सर. Arjun say yes sir, court will put an end. Ronson is laughing, stating that कैसे पता चला सर आपको? Very good. Kavyashri say yeah sir. Interesting है ना? 5. If Mr. X was convicted of traveling on a railway without a ticket with an intent to defraud. Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay. Requesting everybody to stop. Write all the 10th answer ka yes, no, yes, no, yes, no in an order. And then send me a single message. Take them 1 minute's time. Type it. Soch samajh ke. Then we will open the magic box. And then we will try to understand each one of it. Do not type single, 1, 2, 3, yes, 3, 4, 5, 6, no, as any. 1, yes, 2, no, whatever is the answer. You can write yes, comma, n, comma, yes, comma, n, comma, n, comma, yes, comma, whatever it is. Short form, फटाफट type करो. All the 10 answers. No single, yaar. Anaga, Dhruti, no single. It has to be all 10 together as a single message. आराम से टाइप कर लो सर. इस क्वेश्चन ने तो लगा डाली हमारी. Yes, no, 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 yes, no, 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 yes, yes. सर क्वेश्चन हो तो ऐसा 1 yes, 2 no, 3 no, 4 no, 5 no, 6 no, 7 yes, 8 no, 9 yes, 10 yes. No, yes, no, 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 no. Very good. No, yes, no, 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 yes, no, yes, yes. Yes, no, 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 yes, no, yes, no, yes, yes. No, 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 no. Yes, no, yes, 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 yes. क्या इंकी पिंकी पंकी गेम खेल रहे हैं ना? Yes, no, no, no. Sir, first 6 are no, all other are yes. Very good. Yes, no, 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 no. Yes, yes, no, no. Sir, no, yes, no, 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 no. Sir, no, 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 no. Yes, 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 yes. अरे वाह, क्या मस्त इंकी पिंकी पंकी गेम खेल रहे हैं. मजा आ रहा है ना? Okay, how many of you are confident that you will get 10 out of 10? Tarun says, yes, sir, I will get 10 out of 10. Manoj is very clear, नहीं मिलेगा सर. पृथ्वी से नहीं पता सर. सर 50-50 सर. चांस कम है सर. आप ऐसे ऐसे क्वेश्चन पूछोगे तो कैसे बताएंगे सर? Fifth one doubt, so I believe. Fifth one क्या है? Convicted for traveling. Sir, I will get 8 maybe. Okay, how many of you are confident of at least 8? 8 on 10. टकाटक टाइप करो 8 on 10. 8 on 10. फटाफट टाइप करो. Sir, so the answer no sir. It's becoming like restless now. Very good. चलो चैट बॉक्स को क्लोज करता हूं ताकि इजी रहेगा. किधर गया भाई इसका आंसर? ये है क्या? यस. इसको थोड़ा छोटा कर लेते हैं. इसको थोड़ा इधर लेके आ जाते हैं. इसको भी थोड़ा सा छोटा कर लेते हैं. A, active partner, the court will pass an order. First one, yes. Second, dormant partner, court will not pass an order. Third, X had an attack of paralysis, court will not pass an order. It has to be permanent incapacity, it's a temporary incapacity. Fourth, if he had an adulterous relationship, the court will pass an order because mutual trust among the partners will get diluted. So fourth one, काफी सारे लोगों ने no लिखा है. Answer is yes. Fifth, the court will order for dissolution for X conviction because it is affecting the goodwill of the firm. There is a case law. Sixth, omitted to enter a particular receipt. It is not a persistent breach of delivery. Continuously omit, it is a persistent breach, so court will pass. Transfer his entire interest, court will pass. X, Y, or Z, 20 years continuous losses, the court will pass. They are not in speaking terms, court will pass. Yes. Chat box. 8 on 10, 8 on 10, 9 on 10, 8 on 10, 7 on 10. Come on, guys. 6 on 10, 7 right. 7 mila, sir. I got full marks. Padmini, very good. 9 on 10. 9. 6, 8, 10, 5, 7, 6. Good. My dear friend, this particular question will solve all your problem with respect to dissolution of a firm by the court. समझ में आया? Sir, J wala did not understood. My dear friend, X, Y, Z are partners and not in speaking terms. They don't speak to each other. How will they continue the business? So court will say, get lost, and it will wind up. This is one of the ground of just and equitable ground. Sir, explain B. The court may not pass an order because he's a dormant partner, and dormant partner is not known to the outside world, and he does not take an active part in the conduct of the business, and hence court may not pass an order of dissolution. Clear? Sir, E point. Yes, my dear friend, whenever a person gets convicted for dishonesty and with an intention to fraud, which means to say it is affecting the goodwill of the firm, the others will force and the court might allow. What do you mean by the term adulterous relationship? My dear friend, extramarital affair is the word I could say. Clear? Clear है? D1, D क्या है भाई? वही तो बोला बेटा, एक्स्ट्रा मैरिटल अफेयर्स. A1 क्यों भाई, ये समझ में क्यों नहीं आया? How can a friend, okay? My dear friend, any other person is what they have mentioned. The dissolution should be passed by any other person or any of the partner who is of not unsound mind. And any other person includes friend also. Am I clear, Ronson? On behalf of that person, any other person has filed here. Beta, you should not assume they have reserved the right unless and until it is mentioned in the question specifically. Whenever you read the question, please read the question with general terms unless until certain exceptions or reservations have been mentioned in the question directly, indirectly. Am I clear, Arjun? We are talking about the general rules. What if वैसा होता तो, what if ऐसा होता तो question में पूछा है क्या? नहीं पूछा ना? Then go with general rules. Clear, Arjun? कितने marks का question है sir? Each question is 1 mark. And same question पक्का नहीं आएगा. How many of you enjoyed this particular question? Great. Let's move on. कितने magic boxes हो गए? 4. Can we move on to the 5th? The 5th question is again a case-based study. X, Y, and Z are X paid, Y and Z a premium of 20,000 on entering into a partnership for 10 years. And the firm is dissolved at the end of 8 years, which means to say the premium is paid and it has been dissolved before the expiry of such period. Whether X is entitled to recover of payment proportionately in the following alternative cases. If the dissolution is by the death of Y, if the dissolution is due to X's own misconduct, if the dissolution is in the pursuance of an agreement which contains no provision for return of premium, if the dissolution is due to Y's misconduct, if the dissolution is due to the insolvency of Y. Come on, single answers. Yes. Confident of 5 on 5? Case A, B and C, he is not entitled. D and E, he is entitled. A, he is not entitled. B, he is not entitled. C, he is not entitled. D, yes, and E, yes. Am I clear? All correct. 5 on 5. Even insolvency is not entitled. Yes, insolvency, death, it is not. Which one you got it wrong, Vinisha? Explain case C. Beta, case C is told there was an agreement which said even if it is dissolved before the expiry of 10 years, there will be no return of premium. And in such case, the premium will not be given. Am I clear? Point A, can you explain, sir? Dissolved by death of Y. My dear friend, there is a provision for money paid back in case of death of existing partner and insolvency of existing partner. Death and insolvency of an existing partner, you cannot claim back the premium paid. Am I clear? Can we proceed? What are the rights of partners in case of dissolution of account of fraud or misrepresentation? What are the rights of partners in case of dissolution of account or dissolution on account of fraud or misrepresentation? I think there is some error in the answer. Okay, let me just check. I have not checked it in detail. E is if the dissolution is due to insolvency of Y. Okay, E is also coming in here. E is not entitled. Clear? Great. But at death and insolvency of an existing partner, the premium will not be returned back is the thumb rule. Clear? Please switch off your video. You are sleeping in the class, my dear friend. Can we proceed? Please read this answer. Where the partnership is decided on the ground of fraud or misrepresentation, the aggrieved party besides the right under the provision has the following right. He has the right of lien on surplus of asset. He is entitled to rank as a creditor. What do you mean by this term, rank as a creditor? He gets into the shoe of creditor, the right of subrogation, and he is entitled to be indemnified for all the losses which has been caused by other partners. Any doubt? Get money paid as a creditor. Clear? Great. So last 3 questions. What are the effects of change in constitution of a firm on continuing guarantee? It is going to be a 1 marker or 2 marker. A continuing guarantee is a guarantee which extends to series of transactions. Unless otherwise agreed by partners, a continuing guarantee given to a firm or a third party in respect of transaction of a firm is revoked. Come to an end. And from which date? From the date where such reconstitution happens. Am I clear? Any doubt? Sir, what is continuing guarantee? Very good. My dear friend, ABC is a partnership firm and I told Mr. Z, kindly supply goods worth rupees 1 lakh. If they don't pay, I will pay. Because I know XY ABC is a good partnership and all the partners ABC are very good persons. Now, Mr. Z supplied goods, got money, again supplied goods, got money. This guarantee is continued for series of transactions, but to an extent of 1 lakh rupee. But as soon as there is a reconstitution in a firm, either C quits or D is admitted, any ground of reconstitution, the continuing guarantee comes to an end automatically. Am I clear? Great. What do you mean by the term dissolution under Partnership Act and what are types of dissolutions? Let me see who can answer this. Two types of dissolutions, very good. What are those? Compulsory dissolution, winding up of firm, compulsory dissolution and voluntary dissolution. But they are not types, they are modes. That's a different. Everybody has gone to mode of dissolution. None of them have told about types of dissolution. Better they are modes of dissolution. Mode of dissolution only you have voluntary dissolution and dissolution, compulsory dissolution. Yes, somebody at last. Dissolution of a firm and dissolution of a partnership. Very good. इत्तू सा क्वेश्चन कितना दिमाग का दही कर रहा है? And then we say, sir, हमने तो correct लिखा था sir, ICI ने mark नहीं दिया sir. The term dissolution stands for discontinuation. The partnership may be dissolved either of a part. The dissolution may be either of partnership or a firm. Dissolution of a partnership refers to change in existing relation of the partnership and the business continues. But dissolution of a firm means to say dissolution of partnership among all the partners of the firm. In such situation, the firm is discontinued. This is the meaning of dissolution and type of dissolution. Whatever you have told, no, compulsory dissolution, voluntary dissolution, they are mode of dissolution. Type and mode में difference है beta, and 80% of the class got it wrong. Any doubt in this question? Great. What are mode of application of assets in case of dissolution of a firm. How will be the assets applied? Previous answer, please. Clear, Ronson? How will the assets be applied? Very, very simple 3-step formula. Number 1, in paying the debts to the third party. Number 2, in payment to each partner ratably in due to him in the account of advances. Number 3, each partner in due to in their capital. And number 4, divide. So first, outsiders liability. Second, insiders liability. Third, capital. And fourth, profit sharing ratio. Any doubt? Last question of the day. What are rights of the buyer and the seller in case of sale of goodwill by the firm? Whenever the goodwill is sold, come on, what are the rights of the buyer and what are the rights of the seller? My goodness. Unless agreed by the partner, the goodwill shall be include all the assets may be sold either separately or along with the property of the firm. In case the goodwill of the dissolved firm, the right of the buyers and sellers are as under. The buyer can use the firm name, represent himself carrying on the business, and he can also go and meet the old customer and make them the customer. But the seller, he has a right to carry on the competing business with that of the buyer, but there are conditions applied. To advertise for that new business, subject to an agreement between them, they are not authorized to use the firm name, represent carrying the old firm name, and also take care of the old customers. They can carry on the competing business, but again the restraint of trade apply, not within the specified local limit, all those things. Am I clear? So we have understood dissolution, sale of partnership, everything has been understood. All those points which were missed in the notes has been covered here. Sir, can you please explain consequences of dissolution? In case of consequences of dissolution, number 1, winding up of the business will happen, sale of goodwill will happen, all the whole settlement of assets and liabilities will happen. The partners will have the continuing guarantee to wind up, continuing authority to wind up the business will happen. Some 8-9 points have been given. Correct, no, Shreyas? Great. So it's just a heading. If you read, you will understand. Somebody has asked the second question and answer. Mode of giving public notice. So this is the second question and answer. So my dear friends, tomorrow's chapter LLP, and we will be done with LLP in Takatak time, followed by ओ LLP इतना बड़ा है क्या? ठीक है, कल पूरा दिन LLP ही करेंगे. Great. Person will be our last class. Should we revise Companies Act for tomorrow's thing? Answer is no. Tomorrow only LLP and we will try to focus on LLP and complete the LLP. Am I clear? Any doubt? Any doubt, my dear friends? When will be the doubt clearing session? I think the coordinators will surely update you when will be the doubt clearing session. So accordingly, we can plan one doubt clearing session. In the doubt clearing session, we will be talking about additionally some 30-40 questions which might have got missed out or which I believe could be important other than taking your doubts. So we will play a reverse game. First, I will discuss all the questions which I have to discuss. That will solve majority of your problem. If still there are some questions which are unanswered, we will take it up. Is it okay? Great. So with this, wishing you all the very best. Thank you very much and hope you enjoyed the session. If yes, how many of you thought कि आज पूरा 2.5 घंटा लॉ सिर्फ पार्टनरशिप पढ़ेंगे and इतनी सारी कॉन्सेप्ट्स अभी भी बाकी है, हमें पता ही नहीं था. Great. What you think and what I think does not match, so no consensus added. Great. Anyhow, jokes apart, all the very best. Let's start with LLP tomorrow, and we will be starting with LLP at tomorrow 8 o'clock. All the very best. Thank you very much.
Thank you, sir.
Thank you, Atlin ma'am. Thank you, Gauri ma'am.
Yeah, thank you, sir. It was a wonderful session. Thank you, students, for attending this session. Now take a break of half an hour. Then next session starts exactly at 11 o'clock on the topic Bills of Exchange by Adarsh Sanai, CA Adarsh Sanai. Thank you, students. Thank you, sir.
Thank you, ma'am.